Peace, 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 peace. Welcome back to the Universal Temple for the sun, planets, moon, and stars. I'll be your Lord of Hosts, Lord Messiah. And today we're going into the Montevideo Convention on the Rights and Duties of States. So without further ado, we're going to get straight into it. Here's a breakdown. Pay attention, y'all.
Welcome to our exploration of the Montevideo Convention on the Rights and Duties of States. This pivotal agreement was enacted in 1933 and came into force in 1934, shaping international law and state interactions. Montevideo Convention outlines key aspects of statehood, including sovereignty, diplomatic relations, and state responsibility. It serves as a foundational document for understanding the rights and duties of states in the international arena. Article 1 of the Convention. The state is a person of international law should possess the following qualifications. A permanent population. Government and capacity to enter into relations with the other states. These criteria are essential for state recognition.
Articles 2 and 3 emphasize the independence of a state's political existence from recognition by other states. States have the right to defend their integrity and organize themselves freely within the bounds of international law. Article 2. The federal state shall constitute a sole person in the eyes of international law. Article 3. The political existence of the state is independent of recognition by the other states. Even before recognition, the state has the right to defend its integrity and independence, to provide for its conservation and prosperity, and consequently to organize itself as it sees fit, to legislate upon its interests, administer its services, and to define the jurisdiction and competence of its courts. The exercise of these rights has no other limitation than the exercise of the rights of other states according to international law. Articles 4 to the equality of states under international law. Recognition of a state is unconditional and signifies acceptance of its rights and duties, which are irrevocable once granted. Article 4. States are juridically equal, enjoy the same rights, and have equal capacity in their exercise. The rights of each one do not depend upon power which it possesses to assure its exercise, but upon the simple fact of its existence as a person under international law. Article 5. The fundamental rights of states are not susceptible of being affected in any manner whatsoever. Article 6. The recognition of a state merely signifies the state which recognizes it accepts the personality of the other with all the rights and duties determined by international law. Recognition is unconditional and irrevocable. Article 7. The recognition of a state may be express or tacit. The latter results from any act which implies the intention of recognizing the new state. Articles 8 to 10 stress non-intervention in the affairs of other states and the importance of peaceful dispute resolution. States must prioritize peace and apply national laws equally to all inhabitants. Article 8. No state has the right to intervene in the internal or external affairs of another. Article 9. The jurisdiction of states within the limits of national territory applies to all the inhabitants. Nationals and foreigners are under the same protection of the law and the national authorities, and the foreigners may not claim rights other or more extensive than those of the nationals. Article 10. The primary interest of states is the conservation of peace. Differences of any nature which arise between them should be settled by recognized specific methods. Articles 11 and 12 establish that territorial acquisitions by force are not recognized. The Convention respects existing international agreements and emphasizes the inviolability of state territories. Article 11. The contracting states definitely establish, as the rule of their conduct, the precise obligation not to recognize territorial acquisitions or special advantages which have been obtained by force, whether this consists in the employment of arms, in threatening diplomatic representations, or in any other effective coercive measure. The territory of a state is inviolable and may not be the object of military occupation, nor of other measures of force imposed by another state directly or indirectly or for any motive whatever, even temporarily. Article 12. The present convention shall not affect obligations previously entered into by the high contracting parties by virtue of international agreements.
Article 13. The present convention shall be ratified by the high contracting parties in conformity with their respective constitutional procedures. The Administrator of Foreign Affairs of the Republic of Uruguay shall transmit authentic certified copies to the governments for the aforementioned purpose of ratification. The instrument of ratification shall be deposited in the archives of the Pan-American Union in Washington, which shall notify the signatory governments of said deposit. Such notification shall be considered as an exchange of ratifications. Article 14. The present convention will enter into force between the high contracting parties in the order in which they deposit their respective ratifications. Article 15. The present convention shall remain in force indefinitely, but may be denounced by means of 1 year's notice given to the Pan-American Union, which shall transmit it to the other signatory governments. After the expiration of this period, the convention shall cease in its effects as regards the party which denounces, but shall remain in effect for the remaining high contracting parties. Article 16. The present convention shall be open for the adherence and accession of the states which are not signatories. The corresponding instruments shall be deposited in the archives of which shall communicate them to the other high contracting parties. In witness whereof, the following plenipotentiaries have signed this convention in Spanish, English, Portuguese, and French, and hereinto affix their respective seals in the city of Montevideo, Republic of Uruguay, this 26th day of December 1933. Ratifications as of May 2016. Number of ratifications, 16. Brazil, Chile, Colombia, Costa Rica, Cuba, Dominican Republic, Ecuador, El Salvador, Guatemala, Haiti, Honduras, Mexico, Nicaragua, Panama, United States of America, Venezuela. In conclusion, the Montevideo Convention remains a cornerstone of international law, with 16 ratifications, as of guide state interactions and uphold the principles of sovereignty and equality.
Peace.